Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2, Jefferson County, Texas. My name is Judge Terrence L. Holmes. I'm the presiding judge here. You have been asked to come to this court to serve as jurors in a case that we have before us today. Now, on yesterday, you were administered an oath, and the judge at that time had to determine whether or not you were qualified, whether or not you had any exemptions, or whether or not you had any excuses. And so since he did that, since the judge did that on yesterday, I don't have to do it today, okay? And so what we'll do is we're gonna get started with what is called voir dire. And we're going to let the record reflect that the court is convened in this case, being cause number 315529. And the case is styled the state of Texas versus Damaco Grace Crippen. And let the record also reflect that the defendant, Ms. Damaco Grace Crippen, is present. She's present with her attorney, Attorney Jerry Guilford. And then let the record also reflect that the state is present with Assistant District Attorney Daniel Boyd, who is sitting first chair, and Assistant District Attorney Julie Maxey, who is sitting second chair. The court reporter in this case is Ms. Kim Broussard. She will be taking down everything being said, so speak up when you are answering or asking questions. The bailiff is Mr. Charlie Porter, and the defendant stands charged by information with the offense of driving while intoxicated with an open container, which is a Class B misdemeanor. The state and the defendant, through their attorneys, have the right to direct questions to you concerning your qualifications, your background, your experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select a fair and impartial jury to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we may discuss it more privately. And I have a device here so that no one will be able to hear. And this device will block out the noise so that we can discuss your question more privately. Is the state ready to proceed?
State is ready, Your Honor.
Is the defendant ready to proceed?
Yes, sir, we're ready.
Mr. Boyd, the panel is yours, and please limit your examination to 20 minutes.
Good afternoon, ladies and gentlemen. My name is Daniel Boyd. I'm the Assistant District Attorney representing the state of Texas in this case. That also includes the citizens of the state, this county. I work for Mr. Bob Wortham. He's the criminal district attorney here, the elected county. I want to start off saying a lot of summonses were sent out. And y'all answered the call. And I want to thank y'all for that personally, especially with all that's going on in the world right now, and COVID, and taking time out of your busy schedules. It's the most important part of our criminal justice process. ensures that every person that's accused of a crime has a right to a trial by a jury of their peers. And that's what we're here for today. Now, this part of the trial process called voir dire. It means to speak the truth. And that's what myself and Mr. Jared Guilford, the attorney in this case, that's what we asking y'all to do, is just to speak the truth. We're gonna be asking y'all some questions and try to decide your for this case. And it's not so much a, selection process, it's more of a easy. We're gonna be asking y'all questions. And the more you speak up, the more likely it is you won't be on the jury. So that if you don't say anything, the more likely it is that you will be on this jury. So speak up. And they say the more you, those who have nothing to say today, talk walk. So I'm gonna keep that in mind. Now, in this case, as Judge said, we're dealing with the offense of driving while intoxicated. And under Texas Penal Code Section 49.04, says a person commits an offense if the person is intoxicated while operating a motor vehicle in a public place. As the prosecutor in this case, there are certain elements that I have to prove in order for a person to be found guilty of this offense. And the elements in this case, the state will be required to prove that in Jefferson County, Texas, the defendant, Diamond Cole Prison, on or about May 18th, 2017, operated a motor vehicle in a public place while intoxicated. Now, the burden is on the state, and we embrace that. And I don't know if all of you heard, but I'm sure most of you have. Reasonable doubt, beyond a reasonable doubt. And that state has to prove that all those elements beyond a reasonable doubt. And what the courts have said is there's no legal definition, but they have said it does not mean beyond all doubt. So use your common sense. It doesn't mean beyond every bit of doubt. I like to think of it, and here's a couple pieces to a jigsaw puzzle. You start off, you got a few pieces, you really don't know what it is. But as you go along, kind of like a trial, you're presenting evidence, you're putting those pieces together. And somewhere along the way, you put enough pieces together for you to know what it is, beyond a reasonable doubt. Now, there's 3 ways in Texas that a person can be intoxicated. Number 1, 3 separate definitions. Not having the normal use of mental faculties by reason of the introduction of alcohol or drugs to the body. Or number 2, not having the normal use of physical faculties by reason of the introduction of alcohol or drugs into the body. Or having an alcohol concentration of 0.08 or higher. Now, the state only has to prove any loss of the normal use of mental or physical faculties, not a total. So let's look at an example here. Taking Bubba. Bubba's a big guy. He's 6'5", 250 pounds. He's been drinking since he started shaving at age 16. And he puts away 2 or 3 pitchers of beer without slurring his features coming. Does anybody know Bubba? I know. But does anybody, would Bubba be considered intoxicated under the definitions I just provided? What about Mr. Knight?
Johnson Martin.
Mr. Martin? Mr. Martin? Would Bubba be intoxicated under the definition you just gave?
I don't think so with the information you're giving me there.
Okay, he's put away 2 or 3 pitchers of beer. You think he might be over that 0.08 at that point?
I don't have any idea.
What about you, Mr. King?
I don't know how long you've been drinking.
And what about you, Miss Massetti?
Oh, it depends. Ways, any other evidence or any other facts that you could give me?
Sure. Well, we're just looking at saying, look, he drank a lot of beer, but he's not really having the, we're trying to show you kind of he still has his, he's not slurring his speech, he still has his physical faculties. Okay, we're looking at those definitions again. Still has pretty much, it looks like he got the normal use of his mental and his physical faculties. However, if you probably drink 2 pitchers of beer, more than likely, he's probably gonna be over that 0.08, which, again, you'd have to see on that. But what about, well, I got a question. Would anybody want to be on the road with Bubba after he drink 2 or 3 pitchers of beer? What about you, Miss Brent? What about you, Mr. Yarbrough? Is there anybody here who would want to be on the road? Now, let's look at Lily on the other hand. She weighs, and we're kind of going to tolerance here, you know, how much as far as your body and alcohol tolerance. Lily, on the other hand, she weighs 99 pounds. She's never had a drop of alcohol in her life until her wedding day. She has a couple of glasses of champagne, and her balance is affected. Her speech is slightly slurred, and she's making inappropriate comments to her in-laws. Does anyone know someone like Lily? Now, would anyone can think that she would be considered intoxicated under the definitions I just provided? What about you, Ms. McDuff? Okay, under the, yeah, and you're looking at the physical faculties and the mental faculties, and she's, again, not acting herself. What about Miss Trev? Do you think she'd be considered intoxicated under those definitions?
She could be, yes.
Okay. And now, would anyone want to be on the road with Lily after she? Can we all agree we wouldn't want to be on the road with her? And the way to look at this is there's different definitions of the word sick, just like there are different definitions for intoxication. Let's say your child has no obvious signs of being ill, but your instinct tells you that something's wrong. And when you take the child's temperature, the thermometer reads 103 degrees. Can we all agree that this child is sick? Now, let's take scenario 2. Let's say your other child's vomiting, lethargic, has diarrhea. So you take the child's temperature, but he has no fever. Can we all agree that this child's sick as well? We have different definitions of what sick is here, different ways of being sick. Now, intoxication versus falling down drunk. The state does not have to prove in this case that someone is falling down drunk. It's just that merely that they're intoxicated. And the definition of intoxication is broader than falling down drunk. And why is that? Ms. Fontenot, why might the definition for intoxication be broader than falling down drunk? We don't have to just prove that you're falling down drunk, but
Intoxication means that she has consumed a certain amount of liquor,
sure.
and falling down drunk, she is way over the limit. Her level is higher.
Okay. And why might we want it, why might the state want it to be broader than falling down drunk?
Why would they want it to be broader?
Yes, ma'am. To include, you know, more as far as a lesser standard than just falling down drunk. What about this? Why might the state want that definition to be broader than falling down drunk for driving on intoxicated?
I think it would be to give people an idea of what could happen to you if, you know, you consumed even a smaller bit of alcohol than maybe normally you could. If you were caught, tested, that could apply to you.
Sure. And can we all agree, driving a vehicle, you know, that's a heavy machine, it can be a dangerous thing. So we might not have to wait till you're falling down drunk before we might want to try and, you know, be able to define intoxicated and not want you behind the wheel. And public intoxication carries a stricter definition. The state must prove that the accused was intoxicated to the degree that the person may endanger that person or another. And can anyone think why this more stringent definition not applied to DWI? Ms. Mr. Leon? Why might, that would be stricter than the definition rather than, for a driving while stop?
If we walk down the street, drunk, right?
Yes, sir.
Harm yourself, bro.
And maybe it kind of goes back to what we're talking about, a vehicle, you know, being more dangerous.
Do harm to yourself, or others.
Now, the .08, we talked about the three definitions. The .08, blood alcohol content, that's kind of pretty straightforward. Does everybody know we might have, what kind of evidence, what might we have to prove the .08? What about Ms. Yarborough? What kind of evidence might the state present in this case to prove the .08?
Possibly a blood test, or maybe even, I don't know, if the blind test, cost to either test.
Sure, yeah, correct. And that's, some stuff we might present on that. But what we're gonna talk about, what I want to focus on is the other two definitions, which are loss of use of mental faculties or physical faculties. Now, can anyone tell me with regard to driving a vehicle, what are some physical faculties that could be affected if you consume alcohol? What about you, Ms. Moore? Correct. What about you, Ms. Fonda? What's some physical faculties that could possibly be, affected by consuming alcohol when you're driving?
Physically, you don't have all your faculties in line where you can make a good judgment of driving or around or walking.
Sure. Over walking, slur speech.
Exactly.
What about some mental faculties? What about you, Mr. Can you tell me with regard to driving a vehicle, what are some mental faculties that might be affected? Reaction time, like I said, maybe some, the ability to, part of it, to accelerate or navigate. Possibly. So we all agree that the things we just mentioned, the physical faculties, mental faculties, these are very important things when we're driving a vehicle. Now I want to show you all this quick video. Now, walk through this while direct over. Let's say Miss True. We're gonna pick on you. Let's say as far as that, when you saw that ball bouncing, what do you think was following that ball? Now let's assume that you don't make this trip, and you're so excited about that, you're gonna drive straight home and tell everyone that you don't have to listen to me. And so we're basing this on you haven't had anything to drink, any drugs today, okay? On the way home, you have all the use of normal physical, mental faculties, and you see that ball. And your brain, it immediately knows there's probably a child behind it. And your brain sends a message down to your foot, and you immediately hit the brakes. And you're able to stop in time, and probably a scared child, but one that's safe nonetheless. Now, let's change that hypothetical just a little bit. Now, let's say you're so excited that you don't have to listen to me talk for the next 2 days, that you're on the way home, you stop off at a local bar and you have a few drinks. Now, it's nothing crazy. You're not falling down drunk. You're not necessarily slurring your speech. You're just a little bit slower than you. And now when you head home and you see that same ball bouncing in front of your vehicle. And because you're just a little bit slower and your brain doesn't quite send that message as quick, that's the difference between a scared child and a dead child. And can we all see the importance of your mental and physical faculties when driving a vehicle, and why there's those separate definitions, and why it's a broader definition than for if you're just walking down the road by yourself on your, with your shoes on rather than a vehicle. Also, let's look at this. All right, let's say we were on an airplane and the pilot told you over the intercom that he or she had just left the bar and was not drunk, but may not have the normal use of his or her mental or physical faculties. How would you react? What about you, Miss Pacetti?
I would not want to taxi off the runway. I want to get off.
No. Yes, correct. And is there anybody here that would want to get on the plane? Okay. Let's talk about witness credibility. The state, we're going to be calling some witnesses in this case. And how do you determine how much weight to give to their evidence, to their testimony, as far as their credibility and how much you do? Has anybody in here ever been a boss or hired people as part of their job? Anybody in here? Ms. Yarbrough? And did you interview those individuals? And how did you tell, as far as deciding whether or not you would give them the job, what did you look for?
Well, there's kind of that people personality where you can kind of read someone when you're having a personal or a conversation back and forth between one another to kind of tell if they're reaching for answers or if they're truly having a conversation. And then, of course, the pre-research you do before they walk into the actual door.
Sure, and that's like the witnesses in this case, myself, Mr. Guilford, we ask them questions, and if you're on this jury, you determine their credibility by how they're answering those questions. Also, why, as far as determining whether or not you're gonna hire them, do you look at their qualifications,
Yes,
maybe training?
yes.
There's some other things you may hear testimony, qualifications, training, those things, and you decide how much weight to give to that testimony.
Mr. Boyd, you have 5 more minutes.
Thank you, Your Honor. Now, is anybody gonna, give if I call a police officer up here, is there anybody that's gonna give them more credibility just because they're wearing a uniform? Is there anybody here that is? Good. Now, you wait until they speak and you decide based on how they're responding, answering those questions, and whether or not you feel they're being truthful. That's how you determine what weight you're gonna give to their testimony. And all witnesses start off with the same credibility. Now, this is what the state does not have to prove. It does not have to prove that the defendant intended to get intoxicated, that she knew she was intoxicated, or what brand or how much alcohol was in it. Now, I hate to disappoint you all. You may watch these shows, CSI and all these Law and Order and all that. Real trial is not much more boring. Myself and Bill Floyd actually get along quite well. We don't have to jumping up and yelling at each other, or last minute, lab results coming in. It's just not reality. It's a lot more boring than that. Now, I'm gonna ask you kind of a little question here to see what y'all, if driving while intoxicated a problem in our community, who here would say number one, that it's not at all? What about number two? Sort of, but we got bigger problems. What about too many people get beat up? What about number four? Absolutely, people are dying. Okay. What about this law enforcement question? I believe that law enforcement in my community is not doing enough to prevent or solve crime. Is there anybody that has number one? What about number two? They're doing a good job. What about number 3? They're overzealous in their enforcement of the law. Now let's talk about the defendant's right. Defendant has an absolute Fifth Amendment right not to testify. Is there anybody going to hold that against Ms. Griffin if she decides not to testify? She has the right to remain silent, the right to legal counsel, the right to a jury trial, the right to a presumption of innocence, and also the right of subpoena power and the right to testify if she chooses. Let's talk about the range of punishment here. This is a Class B misdemeanor case. It's up to 180 days in jail and up to a $2,000 fine or probation. Is there anybody here that's based on, religious beliefs or otherwise that they just can't pass judgment on another individual? They just couldn't, either way, whatever. I thank you all for your time. And for taking time on your busy schedule to be here. I really do appreciate it.
Mr. Guilford, you may proceed.
He's right. We actually do get along. I didn't even call him a friend. Notice he's plugged in a flash drive for him because my computer won't hook up to that. Okay, tell you a little bit about me. My name is Jared Guilford. This is me and my family on one of our vacations. I have 4 kids. Me and my wife were a little crazy. We have 4 kids in 4 years. Yeah, we're crazy. It's fun. I love it. Love everything about it. I live in Vidor. My office is right here in Beaumont. I have these 2 partners. This is a picture of the 3 of us. I'm Jared Guilford, the guy in the middle. The guy on the right is Mr. Jonathan Stovall. Hopefully you don't know him because he does family law. You can know him. Doing something like custody fight or divorce stuff. I don't deal with that. But that's what he does. Then the guy on the left, he's actually right here because my other partner, and he and I both do criminal defense work. On this day, we took these pictures. We said, okay, let's wear blue suits. Dustin, he can't comply. He just can't do it. We'll talk a little bit about perspective. Anybody here does not drink, yet to have their first sip besides me? Okay. Sometimes we're told one story, when things are quite different. There was a news story a few years back. Who remember seeing this picture? I'm going to pick on Bridget because I know her. Who is that in that picture? Can you tell from there? Oh, it's too far. Sorry. Can anybody see who that is in that picture?
Prince William.
Yes, it's Prince William. Supposedly he flipped off a bunch of people, right? He's you have it on the finger. When in reality, this is what was happening. This is the other perspective. Anybody remember that story? It was reported that this was what happened. Somebody had that shot, and boy, it was a big story. They had it. He was caught living off these people. But then it came out, it didn't last very long because the truth came out, this is what happened. But a lot of people would see this and they would say they have no reasonable doubt that it happened, right? I mean, you look at that picture, you go, and somebody tells you he flipped a bunch of people off, and you look at that picture, and what do you say? Of course it happened. I saw it. I'm looking at it. But if this is reality, driving while intoxicated is, as we heard, includes Jefferson County. That's hardly ever an issue. I've never seen jurisdiction be an issue. Operation of a motor vehicle has to happen in a public place. Parking lots are considered a public place. That's not an issue in this case either. But it must happen at the same time. Okay? You have to be intoxicated while operating a motor vehicle in a public place. Why do we have DWI laws? Mr. Martin, why do we have DWI laws?
Because people in the state decided to.
Is it dangerous to drive while intoxicated?
Yes. I'd say so, yes.
This is why we have DWI laws, right? It is dangerous. I'm a criminal defense lawyer. I'm not pro DWI. I'm not telling y'all to go get drunk and drive. I'm very anti-driving while intoxicated. This is why we have it. It's very dangerous. The reason we have DWI is a lot of people suck at driving when they're intoxicated. Can't do it well. There's too many reasons not to now. If you're drunk, you make it home. What are some of our options? Mr. King, what are some of our options? Had too much to drink, what should you do?
Call friend, like you have it up in the line, over a taxi, many options.
How about that?
No,
No. Why not?
you're still in the vehicle, you're in the driver's seat. I think it's against the law in Texas.
Why is that against the law?
I believe it is, when you have the keys in the ignition.
Okay. We have here our elements: intoxication, operating a motor vehicle, and public place. Is this gentleman operating that vehicle? So under Texas law, who thinks that this would be illegal? If you're drunk doing this, who thinks that should be illegal? Anybody here think this should be illegal and fits the definition of operating a motor vehicle? Anybody agree with what you would say, but then you,
The vehicle running. Be going out there, I don't know.
is that considered operating to you if a vehicle is running?
Yes.
Yes. Anybody else agree with Mr. King that a vehicle, sleeping in a vehicle running is operating a motor vehicle? I see a head shake here near Mr. Anglin, is that right? They have the seating chart, it's different than it normally is. Normally they seat up straight across.
If it's running, I agree.
I think it depends on where he's at. I mean, are you running and it's at a red light? Or are you in a parking lot and you just turned the car on so you didn't sweat to get in August?
Okay, does that change your opinion too, where it's at? No.
No, if it's running, things can happen.
I couldn't hear that.
Not be running.
Should not be running. If the court systems have litigated that issue already and told you that sleeping in a car while it's running is not operating a motor vehicle, could you follow the law, or would you still consider that operating a motor vehicle anyway?
Follow it, but that's
That's
law.
the law.
The law. Well, yeah, driving down. I'm surprised.
You'd be surprised.
I'd be surprised.
Okay. Let's talk about policy. DWI policy. We talked about that a little bit already. Why is it bad to have it? Why do we need DWI laws? Why is it Why do we have them? Because people are terrible at driving when they're intoxicated, right? This is another example of somebody that can't drive right. I don't know the seriousness of the internet picture I took. No, nothing to do with that. But is it, if somebody has a choice, they've had too much to drink, between that or risk it and try and go on home, which would we prefer? Why? Mr. Taylor, I know you too. You want to take on you? Why should we prefer this? But if this is driving while intoxicated, if that's operating a vehicle, I'm gonna go to jail anyway. Why not just risk it? Go on home. I'll tell you what, because that would be bad policy. That would be terrible. That wouldn't make any sense. If you're gonna go to jail because you've had too much to drink in your car, that would be, and you said, man, I should not be on the road. Sleep this off. The cop comes right out of your car and arrest you. That would be bad policy, right? You may disagree with me that that would be bad policy. We'll talk a little bit about reasonable doubt and what that actually means, because Mr. Boyd said we don't have a straightforward definition on it. Again, there's a lot of things of what it isn't. And on this chart, we have no evidence, means nothing. There's a scintilla of evidence, that means reasonable suspicion, probable cause. I've heard that term before. People watch these talk shows. You have preponderance of the evidence. That's the greater weight. That's what happens in civil court. Is it more likely than not? We have clear and convincing. That's what they use down in CPS court. Terminate rights of parents. You've got clear and convincing evidence. You want to terminate someone's rights, their parent. And then you have the highest standard, and that's reasonable doubt. And you are allowed to draw inferences, and Mr. Boyd pointed out, it's not beyond 100% doubt. But I will use his slide. He used this slide. I can't present two PowerPoints at one time, but he used this slide, and we think we know what this is, right? What is this, Mr. Martin? What's that appear to be? He had it up on the side. Do y'all remember? Mr. Yarborough, you're shaking your head. What is it?
Firearm, crystal.
What if that were the missing piece? I've written toy there and highlighted it. What if we're written in red on that one piece that we're missing and said toy? Would you still say that's a firearm?
It would be a toy firearm.
Be a toy firearm, but that, under the firearm statutes, that wouldn't qualify as a firearm, right? Yeah. So sometimes it's, we think we might know it all, and we don't. Just like in this. Sure, it looks like a gun. But if we're missing the word toy written on the side, I think it's convincing quick. It's not always what we see. And does that mean that if you were to look at this picture without my writing toy on it and say that's a gun, would it be unreasonable to think it's possibly a toy?
Well, toy guns would have a cigarette barrel with a different color. And I could paint toy on a real gun and it could still be a gun.
Right.
Doesn't mean it's still a toy.
But I'm saying, would that doubt be unreasonable to think it's possible that it's a toy gun?
Just because it's written on there, I still wouldn't think that it was a toy. Just
Okay.
because it's written on
Would that doubt be unreasonable though?
there. My experience with firearms.
Okay. Just looking at a picture of it at a distance, not handling it, just having a picture of a firearm. You think it would be
That picture, I would not compete this as a toy.
You couldn't be convinced it's a total, or you could?
I don't think so.
Okay. I got it.
Based on it just being written toy, that would not sway my opinion.
Okay. Like I said before, a lot of people could see this picture and tell you they have no doubt that that happened. They have no reason to doubt that that happened. So when you're sitting here listening to this trial, I don't want you to just think about what we know. I'm inviting you to think about what we don't know. Look forward to presenting this case to you. If you're unlucky enough to get stuck with us, thank you.
Okay, ladies and gentlemen, we're going to ask that you will step out into the hallways, follow the bailiff, and just please be patient because we may have to call some of you in to do some follow-up questions. So just follow the bailiff. Does any one state, do you have any, anybody you would want to use a challenge for cause?
No, Your Honor.
Any questions? Mr. Guilford? Okay, so at this time, what we're gonna do, we're gonna be in recess and we'll give each side 10 minutes